This week at the Supreme Court, after 7 years, the Session Hall of the Supreme Court of the Philippines, Baguio City, opens its doors once again. This time for the continuation of the oral arguments for the Philhealth cases. Held on April 2 and 3, 2025, the court resumed and concluded the oral arguments on the petitions regarding the transfer of the 89.9 billion peso excess funds of the Philhealth to the National Treasury. 3 petitions challenged the return of excess reserve funds from government-owned and controlled corporations to the National Treasury to fund unprogrammed appropriations. Matters discussed included the Universal Healthcare Act, particularly the sections on premium contributions and program reserve funds, as well as current contributions of members and case rates. Among those called for interpellation from the side of the respondents were Solicitor General Menardo Guevara, Secretary of Finance Ralph Recto, Government Corporate Counsel Solomon Hermosura, Philhealth President Dr. Edwin M. Mercado, and Philhealth Senior Vice President Renato Limsiaco Jr. Counsels for petitioners, Attorney Nery Colmenares, Attorney Paula May Tangkeying, Attorney Christopher John Lau, Attorney Maria Kristina Piambot, Attorney Jose Sonny G. Matula, and Attorney Catherine Jessica Destor Ginigundo also answered questions from the justices. The amici curiae included former Department of Finance Secretary Margarita Teves, Health Economics expert Dr. Orville Jose Solon, Ibon Foundation Executive Director Sunny Africa, and Public Budget Analyst Ziza Nadine Suzara. The court required the parties, including the amici curiae, to submit their respective memoranda within 30 days. The Supreme Court has ruled that companies issuing registered securities must use only certified public accountants or CPAs accredited by the Securities and Exchange Commission or SEC for independent audits of their annual financial statements. The court en banc through Associate Justice Ricardo R. Rosario declared valid Rule 68, Paragraph 3 of the Implementing Rules and Regulations of Republic Act No. 8799, otherwise known as the Securities Regulation Code, and SEC Memorandum Circular No. 13, Series of 2009. These rules require CPAs serving as external auditors for corporations issuing registered securities to obtain SEC accreditation. The SEC held that the Accountancy Act does not limit regulation of the practice of accountancy to the Professional Regulatory Board of Accountancy. The Securities Regulation Code and the Revised Corporation Code give the SEC powers to implement the state policy to protect investors, ensure full and fair disclosure of securities, and minimize insider trading, which harms the free market. The court said the accreditation requirement is not a regulation of the accountancy profession, but the specific activity of auditing. Thus, CPAs engaged merely for bookkeeping or other non-audit services are not required to be accredited by the SEC. The Supreme Court has clarified that the time limit or prescriptive period for prosecuting crimes, including those under the 2022 Rules on Expedited Procedures, stops running once a complaint is filed with the Department of Justice, not when the case reaches the court. In a decision written by Associate Justice Henry John Paul B. Inding, the SC en banc abandoned its rulings in the 2023 cases of Republic v. Desierto and Corpus Jr. v. People, which previously held that the prescriptive period for crimes covered by the 1991 Revised Rules on Summary Procedure stops only when the information is filed in court. The SC also clarified that under Section 281 of the 1997 National Internal Revenue Code, the prescriptive period for criminal tax offenses that are not immediately known starts from the time the violation is discovered. The prescriptive period is interrupted once a preliminary investigation begins. The Supreme Court's Committee on First and Second Level Courts Performance Evaluation held the second leg of the Performance Development Framework, or PDF, for the High Performance Courts in San Juan, La Union on Friday. Led by the Office of Committee Chair Associate Justice Alfredo Benjamin S. Caguiwa, the project aims to ensure the creation of an environment of excellence in court performance, both qualitatively and quantitatively. Deputy Court Administrator Leo T. Madrazo led the discussion on the salient features of the PDF, which will enable courts to track and evaluate their individual performance and make use of tools and trainings in order to make improvement. The Office of the 2025 Sharia Bar Chairperson, Associate Justice Antonio Tico Jr., has issued a notice to the 2025 Sharia Special Bar Examinations, or SSBE, applicants on the local testing centers and venue assignment for the 2025 SSBE. The 4 venues for the 2025 SSBE are University of the Philippines, Diliman and Quezon City, Mindanao State University Iligan Institute of Technology, Ateneo de Davao University, and Ateneo de Zamboanga University. Starting April 7, 2025, the 2025 SSBE examinees may access their assigned testing venue through their respective barista accounts. And that's your Supreme Court this week. I am Tiffany.